30 minutes. That's how much time Arthur Gochman has to convince the Supreme Court of one important point, that education is a constitutional right. This may seem like an arbitrary point that has no relation to today's classrooms, but these minutes on October 12th, 1972 would paint the future of education forever. Because if education isn't a constitutional right, then how can the federal government mandate any level of excellence? Arthur's hands are sweaty as he grabs his papers and walks before the 9 Supreme Justices to his podium. As a small lawyer in San Antonio, he wonders how he got here. He had spent the last 4 years preparing for this moment, but would it be enough? The opposing counsel was a leader in the legal field. Charles Allen Wright had written the handbook on Texas law and had the finances of the Texas government behind him. Arthur was a local civil rights lawyer who had never stood before the Supreme Court. He was the underdog, but like any good Cinderella story, we always want to root for him. Arthur cleared his throat and began, "Mr. Chief Justice." And with those words, and the ones to follow, education would never be the same. Arthur's journey to the Supreme Court started many years before he stood before those justices. In 1968, parents from Edgewood School District came to him to advocate that their children get a quality education. You see, in Edgewood, each student received about $356 per year to fund their education, while in Alamo Heights, just 20 minutes away, students were getting $594 per student. That's almost 70% more per student. Not only were Edgewood students receiving less funding, but the residents of Edgewood were being taxed 20% more than the Alamo Heights residents. However, because the property values were so much lower, Edgewood still raised significantly lower per student. The parents were beyond disheartened. They wanted to give their children a fighting chance to succeed, but felt like the financial disparity made that more and more difficult. The parents came to Arthur, asking him to take up their case, and one courageous man stepped forward to be the official plaintiff, Demetrio Rodriguez. And the San Antonio School District versus Rodriguez case was formed. In 1971, Arthur presented the case in front of the U.S. District Court. In front of a panel of 3 judges, he shared the inequity within the finances of the Texas school districts. And he won. But the celebration was not long won, because in 1972, the state of Texas appealed the case to the Supreme Court. What was originally a case between 2 neighboring school districts about funding was now in a different playing field, and arguing something much bigger than equity in Texas school funding. To win this case, Arthur would have to convince the Supreme Court that education was a fundamental right according to the Constitution. Arthur understood the weight of this case being brought to the Supreme Court, a court that wouldn't just decide what happens with this case, but ultimately decide what is possible for everyone who follows. A year after winning the case in Texas, Arthur is standing in front of the Supreme Court. 4 years of legal prep, years of parents advocating for their children, and it all comes down to these 30 minutes. Before Arthur comes to the podium, the justices have grilled the opposing counsel for Texas, Charles Allen Wright. One justice, William Rehnquist, even asked a basic question that stops everyone in the room. Is it even required for the states to provide an education at all, according to the Constitution?
Do you know of any case from this court which has ever held it would be unconstitutional for a state simply to get out of the business of public education, bag and baggage?
Charles answers back, I don't know of such a case, confirming that there is nothing constitutionally holding back states from closing all educational schools, according to the Constitution. This case has taken the issue of school funding to another level. Arthur started this case to help create equality in funding for students, and here is the judge asking if any funding at all is constitutional. Arthur shakes his head and wonders if he's done more harm than good in opening up this argument. By arguing that education is a constitutional right, if the judges vote the other way, it could take education away from everyone. Before, it had been an ambiguity. Now, it would be definitive, one way or the other. Arthur stands up to make his claim. He claims that education is a right because it is a citizen's duty to vote and serve jury duty. And how can a person fulfill this duty without being educated?
Education affects matter guaranteed by the Bill of Rights. It's a preservation of other rights.
The justices push back. They ask how this would logically shake out. This is where Arthur's argument begins to struggle. He can't give specifics to his argument, and some of the justices keep asking him to define a workable rule. They want him to explain how the courts could actually enforce an educational right equally. In the midst of this struggle, Arthur plunges forward into his next argument. He appeals to the humanity of the situation.
In other systems, we wouldn't have a lawsuit. A person can move from one district to the other. But here, the poor are stuck in the poor district, and they have no mobility. The Edgewood people would like to live in Alamo Heights, but they have no way to do it, and the only way they can get a fair education is to get out of Edgewood.
Justice William Rehnquist takes in this emotional plea, but returns to the logical argument.
But there's got to be some consistent principle that governs the decision, rather than just saying, this is really bad, or the other wouldn't be so bad.
And this is really the crux of the issue Arthur has. His argument may be logical and emotionally valid, but the justices need legal precedents to make a decision. The justices continue to question Arthur. It is a bit unsettling, and unlike other court scenarios, justices can interrupt you in the middle of your train of thought, and they expect quick, educated answers. At one point, Arthur says, quote, "I have lost my train of thought on that," but he later finds it again. This is where his opposing counsel, Charles, has an advantage. Charles has argued before the Supreme Court before and knows what to expect. His legal side also has the money to finance mock trials, where he would have practiced this scenario multiple times before coming before the Supreme Court. But Arthur holds his own and finishes strong. He brings up supporting cases and again appeals to the justices' humanity. He even reminds them the San Antonio district, the one whose name was on the Supreme Court case, had ultimately changed their position and now supported Arthur's case. His 30 minutes are now up, and it's time for the Supreme Court to not only decide Edgewood's fate, but the fate of public school as a whole. Would the Supreme Court agree that education was a constitutional right? The justices file out, and Arthur lets out a sigh. Only time would tell. The answer came on March 21st, 1973. With a vote of 5-4, the Supreme Court sided with the state of Texas. Arthur Gochman and the parents of Edgewood had fought hard, but the final decision had been made with a slim margin of one vote. And with it, one thing had now been made clear: that education was not a constitutional right in America. That decision may seem like a legal technicality, but in reality, it would radically shift the entire educational system. Think about today's classrooms and the behaviors that are making learning at times almost impossible. It all comes back to this Supreme Court decision. And here's why. When education isn't a constitutional right, there's no requirement that it actually has to be good. Students can spend years in classrooms not learning anything without any legal repercussions. So what are schools actually being held accountable to? What truly incentivizes the system? One word. And it's the one thing Arthur was fighting for in the very first place: money. And the money today doesn't reward learning, but rather having kids in classroom seats, or in other words, attendance. Most districts are pursuing 3 types of funding, and these reward compliance over competency. The first is local property taxes. Your zip code determines part of your school budget. This is what Arthur was fighting for initially. The second is state funding. Most states give that money based on attendance, not outcome or whether classrooms are functional, just kids in the building. The more warm bodies, the more money. The third is federal money. Title I for low-income schools, IDEA for special education, and grants tied to how students are classified. And here's the thing about federal money: it follows categories, not results. The more students a district classifies under federal programs, the more money it receives. Whether it's property taxes, state funding, or federal money, they all incentivize students simply being present in school. I'm not saying this is right or wrong, but I am saying it has consequences, especially when it comes to classroom behavior, because suddenly students staying in the room is more important for funding than learning. And this priority plays out in classrooms across America right now. Picture that student with highly disruptive behavior, a student who is making it genuinely impossible for the other 25 kids in that class to learn. The teacher wants a consequence, wants that student removed, even temporarily, so the rest of the class can learn. And the school district runs a calculation. Every day that that student isn't in the building is attendance money gone. If a student has an IEP, removing them triggers a federal review process the district has to staff and defend. And if the student's removal creates a disparity in the discipline data, the district risks a federal civil rights investigation that could threaten their entire funding system. So the rational move financially is to keep a student in the classroom and hand the problem back to the teacher. And when the teacher pushes back and says, "I have 25 other students who deserve to learn and this isn't working," the district can't say they're protecting their funding. So instead, they hand teachers a convenient philosophy. Have you tried a restorative circle? What does your relationship with the student look like? Exclusionary discipline is harmful. We've evolved past that. And now, the teacher isn't raising a legitimate concern. The teacher has the wrong mindset. The funding conversation is gone. And in its place is a whole philosophy about healing and empathy and trauma-informed practice, which sounds great. But what it's really doing is covering for a system that can't afford to do the right thing. A system that can't afford to prioritize learning over attendance. students and is hoping we don't notice. And suddenly teachers are wondering if they're educators or babysitters. Is the purpose of schooling to learn or just a mass-scale daycare? And how do the school districts get away with it? Because there's no constitutional obligation for learning in schools in the first place. That's exactly what Arthur Gochman was trying to tell the Supreme Court in his argument. Describing education, he says,
"It's the only thing the state provides that it compels you to utilize."
The state forces children through the school door every single day. Compulsory attendance is the law, but the quality of what happens once they're inside, not required or guaranteed. And it's not anyone's legal problem. So the system can rebrand a budget problem as compassion, and nobody can take them to court over it. The teacher can be told to try a restorative circle instead of a consequence, and there's no constitutional floor that says that's not good enough. Gochman saw it. He tried to tell us. The state can't compel your child to be somewhere and then accept zero responsibility for what that place delivers. But he lost, and we've been living with that loss ever since. March 21st, 1973. The court claimed education was not a constitutional right. But then something strange happened. Schools kept existing. The buses kept running. The students kept coming through the front doors, and teachers kept coming to work. The federal government still showed up with billions of dollars in funding. States still passed compulsory attendance laws. The Supreme Court said we didn't have to run schools, and yet we did it anyways. We built the whole infrastructure. We fund it, mandate it, staff it, require students to be there, but then draw the line at quality. Nobody said it has to be good, that there's a standard to meet. We're still doing public education. We just decided that doing it well was optional. And I think that's the conversation we are long overdue to have. Not just about funding or behavior or about PBIS or restorative justice, but about what we actually owe children in exchange for the 13 years we demand from them. Because if you're going to compel something, if you're going to make it the law, then the bare minimum should be that you make it worth showing up for. Our children deserve more than a system that requires their presence and ignores quality. And so does every teacher trying to hold that system together from the inside. I think all of this comes together to raise one important question. If you're going to do something anyways, why not do it well? Thanks so much for watching Educator University. I'm Annie, and if you like this video, then you're going to love this one.